perhaps try to ensure that the implementation of the local government functions are actually done according to the law. They need to regulate them. It's either they just pass or enact a specific policy that requires a particular implementation to ensure that there is effective performance of municipal functional areas. And the last one is intervention. So the failure to comply with such regulations, it invokes intervention in local government, and intervention is captured in section 139 of the Constitution. And one of the provision under section 139 is that when a municipality cannot or does not fulfill an executive obligation in terms of the constitution or legislation, the relevant provincial executive must intervene by taking any appropriate steps to ensure that the obligation is fulfilled. And now I would like to deal with the financial matters. So since this chapter is about multi-sphere of government, where there are different levels of government, there is also the need to ensure that the finances of or the financing of municipalities and the provincial governments are also provided for in terms of the constitution. I indicated earlier that provinces share similar responsibilities with national governments. However, when it comes to physical capacity or physical authority, they have limited powers. Then some of the people are questioning, how come can you share the same responsibilities but not the same financial powers? It is more of an imbalance on the part of the provinces, looking at the kind of functional areas that are allocated to both of them. These resource intensive and high impact resolutions, they require a lot of resources. With the more simpler term, they require a lot of money for such functions to be completed. For instance, education, housing, libraries. These they require a lot of money, so it's impossible for provinces to actually execute their constitutional duties without sufficient physical resources. And the part of multi-sphere of government, it falls within the very broad physical decentralization. Decentralization is about sharing power with the lower levels of government. Then with physical decentralization, it's about the allocation of financial resources and revenue generating authority to provincial governments and the municipalities. It also concerns the degree of fiscal autonomy, which is about the right and the ability to manage local revenue collection and expenditures without any encroachment from the higher levels of uh, government. So the provincial sphere may have the power, if regulated by an act of parliament, to also generate its own revenue, although currently the fiscal powers of the provinces are too limited. Then the municipalities, which is imposed with the developmental duties itself, can impose or generate revenue through or imposing rates on properties and fees for services that it provides by on its own or through other service delivery agents, and can also impose other taxes, levies, if authorized by an act of parliament. Now, this is the last slides where I'll deal with the distribution of revenue. Provincial and local spheres have got the right to an equitable revenue that is collected nationally. This is the intergovernmental transfers where they are apportioned a certain percentage of the money that is raised nationally. Again, there is the Fiscal and Financial Commission that is constitutionally mandated to provide recommendations on the equitable division of revenue. The FFC plays a crucial role in terms of ensuring that municipalities are kept with municipalities and provinces. I mean, they are kept with sufficient resources, although most of its recommendations are not legally binding on the national sphere of government. That's why they are referred to as recommendations. In most cases, commissioners that are appointed within the FFC, they also cry foul of the failure by the national government to comply with some of the very crucial recommendations with regards to the equitable division of revenue. Then the budgetary processes are meant to ensure that there is a transparency, accountability, and effective management. If you look at the local government, you have got the Local Government Municipal Finance Management Act. That's an act that has been specifically promulgated to ensure that the management of finance and budgeting at the local level of government is actually up according to the required standards. Then for the national and provincial spheres of government, there is the Public Finance Management Act that is meant to ensure that there is a similar financial management and performance at these senior levels of government. Then lastly, the Constitution also provides for the establishment of the central bank. Okay, come to the end of the lecture. I'm not sure if whether Prof. Lee, you will preside over the question and answer session. But I'll still be responsible for the answering, just to ensure that there is order in terms of answering questions. Thank you. Hello?
Paul, I can hear you, but something did seem to go wrong. It's gone back to the beginning of your slide. Did you say you were finished with the slides?
Yeah, I'm done with the
okay.
The lecture,
okay.
yeah.
Okay, no, that's perfect. Yes, so students are saying that they've got no, there are questions. Okay, let me get back to the right page. So Letuma has a question. Letuma Bosaletsi, let's ask your question first.
Yes, thanks, Prof. And thanks, the lecturer, for the wonderful session. I just want to find out quickly. I think towards the end of your presentation, you indicated that the tax, you're talking about the tax whereby the local spheres, they can also charge the levies and all those kind of things. But now, in an event now whereby those levies are being charged to the community, but the local municipality is not sufficiently provide such services, like maybe, or maybe they don't provide them sufficiently, so by they're charging the full rates. What recourse do the public or the residents have with that regard? Will they maybe keep their money, say they won't pay anymore, or what?
Oh, all right. Thank you so much. I will prefer that I will directly answer each question immediately after it has been imposed, so that I wouldn't lose track to the questions. What I could state is, firstly, a municipality cannot charge for services without a bylaw that provides for the charging of property rates. That's why we find that at the end of the day, some of the services that the municipalities provide could be for free, especially in rural municipalities. Then, if the municipality is charging for services and still people are dissatisfied by the provision of services that they receive from the municipality, residents do not have the power or the rights to abstain from paying for such services. They are still required to pay for such services, because at the end of the day, it's a matter of the municipality ensuring that it amplifies the provision of services to the one that reaches a quality service delivery. Failure to pay for such services might result in one having a higher municipal bill, and the municipality won't renegade in terms of ensuring that at the end of the day you are accountable for paying such bills. As an individual resident, you could end up being in trouble with the law. And with the example that I have seen mainly in the municipality that I myself reside, is the Musina local municipality in Limpopo, in the northern part of the municipality, which is one of the rural municipalities around. What happens is, the failure to pay for services may result in one being cut off of electricity supply, and at times they also close the water taps, just to ensure that you are able to pay for such services. I hope I've been able to answer your question.
Yes, you have answered, but I'm hearing the issue of the what consequences that you will have as a resident if you are not paying for them. But in any other way, what I'm saying is that now you are paying, but municipality is not delivering what they are supposed to be delivering. I was talking to that because now what can people do and all that.
Oh, okay. Usually, the common way for people to find solution to such problems is to engage in peaceful strikes as a group. They come in a form of a pressure group, just to ensure that the municipality at the end of the day it fulfills its service delivery mandate. Again, if you are individually affected, you could approach the municipalities administrators, engage them, explain to them what's happening. In most cases, people are able to find the solution. In others, where municipalities have got the ward-based system, which is you may find that a municipality, half of the of councillors in the municipality are ward councillors elected to represent a particular constituency made of a ward. You can engage with the ward councillor who will represent you within the municipality itself, but within the municipal council session, because there is a political administrative interface between the administrators and the politicians. So councillors cannot just log into the administration offices, push for the issues of their own followers or people within their wards to have a solution immediately. So they can do so within the given structures. And again, a WAST-based system has got a municipality can choose that within its WAST-based system, it has got what is called ward committees. So these ward committees, they are the interlink between the communities and the municipal council, and the ward committees are obviously comprised of the ward councillors as the chairpersons. So we find that the ward committee members, they often drive the best interest of the communities or residents at heart. So these are some of the solutions which one could utilize in order to ensure that the service delivery issues which you might be encountering as an individual or collectively are able to be addressed. Thank you.
Pilani, are you ready to ask your question?
Yes. My question came in the term of revenue collection. I'd like to understand that, you know, since they say like the sole mandate of revenue collection lies within the Department of Finance. That's what I read, and I think that's how I got it in the textbook. So, and then there's just certain amounts of levies that the municipality can actually charge in the municipality. So, which portion of the revenue made by the municipality goes back to national and then gets distributed back to the municipality, and which part of it is just, you know, money that is used within the municipality?
Oh, thank you.
All right, thank you.
All right. Actually, the Constitution provides for what is called the intergovernmental transfers. If you are to interpret the provision for revenue generating powers through the lens of multi-sphere of government, one could be able to clearly perceive that seemingly municipalities are not actually required to collect revenue, then transfer it to the higher levels of government. It is actually the other way around because of the intergovernmental transfers, where a certain there has to be equitable division or sharing of revenue from the national government. So the revenue that the municipalities collect from the services of which provides to its communities or residents are meant to ensure that its financial capacity is still trying to ensure that there is a continuation of services that are provided. Failure to reach a certain point of financial capacity might lead to the declaration that a municipality does not have financial viability. That's why we find that some of these municipalities are dissolved, then amalgamated in other municipalities. And there are issues with regards to intergovernmental transfers. They do not wholly sustain municipalities to have a financial capacity. That's why I'm saying the lesser the services that are charged by the municipalities, the lesser its revenue in terms of continuing with the provision of services. So it's more of a tricky system in the present juncture. So the collection of revenue at national level could be done mainly through SARS. After that, then through the rightful channels, then there has to be a better distribution of a good distribution of such revenue in an equitable manner to provincial governments and local governments. I guess I've been able to answer your question.
Yeah, you have been able to answer my question, but it also just led to more questions. But let's just move on to other people. Let me not hog the time.
Right. Thank you. Any further questions?
Karabo Njomane.
Yeah, thank you, ma'am. My question is based on the difference between the level and the spheres of government. I see on slide number 4, when the divided model was explained, it appears that levels and the spheres are the same thing. So I want to know the difference between the levels and the spheres of government, because I thought that the levels of government was used during the apartheid era, and then when after 1994, the term levels of government was abolished, and then the spheres of government was introduced. So I just want to know the difference. Thank you.
Oh, all right. Thanks for the question. What you need to know is, although in South Africa we use the term sphere according to the preferences of the Constitution, however, the broader terminology for multi-level government is that the experts in issues concerning federalism, multi-sphere or multi-level government, decentralization, they use multi-level government. This is often used as a replacement to some more of what I could refer to as controversial terminologies such as sphere and tier. Multi-level, it seems like it's a broader concept that encompasses both. Then with the sphere, it is more of ensuring that there is a non-hierarchy in the different levels of government, although we know that the national government is higher, then followed by the provincial government, then the last one is the local government. The requirement for cooperative governance is that they are interrelated. Then there is also a principle of interdependence where there has to be a mutual trust and the requirement to work in good faith. So they need to promote effective, efficient, mutual intergovernmental relations within the ambit of the Constitution. There is no need for competition between them, but cooperation. So that's when the terminology of sphere comes in. Then in the context of Zimbabwe, for an example, the Constitution of Zimbabwe, it speaks of different tiers of government. Why? Because in Zimbabwe, they do not have a federal or quasi-federal system. Zimbabwe has got a unitary system, although there are similar levels of government made of the national, provincial, and local spheres of government, but there is a hierarchy of power. The provincial and local spheres of government, the provincial and local levels of government do not receive their powers directly from the Constitution, but from a legislation that is passed by the national government, which decides when, how such powers needs to be exercised. So there is a complete hierarchy in the context of Zimbabwe. Then in South Africa, it's a different story altogether, both in terms of the wording and practice. And there are some of the experts who argue that it's not just a matter of terminology, but it's a matter of what's happening in practice. But myself, I still argue that as long as the Constitution is the supreme law of the Republic, what it provides, it also needs to be translated into reality in practice. And South Africa is a very strong constitutional democracy. And you are right where you indicate that in the pre-1994 constitutional dispensation, there were they used the term level instead of sphere. But what I can emphasize myself now is that a major change is that the local government then was a creature of statute than a creature of the Constitution. Currently, the main change is that it's constitutionally recognized and it has got constitutionally protected powers. the higher levels of government cannot just at any time infringe or encroach on its institutional geographical integrity without following the due procedures required by the Constitution. Thank you.
Thank you very much, sir.
My pleasure.
And now I think it's Walter. I saw, yes, Walter's hand is up.
Yes, ma'am. Thank you. From me, I think it's more of a comment than a question, especially on the local sphere of governance. I think there's a speaker who asked a question about the in cases where the municipality is not performing into their statutory obligation to the ratepayers. What is the recourse that the ratepayers have? I think that question is a question that I think I needed to make a contribution on, because the reality of our South African situation is that many municipalities are underperforming. And that frustrates a lot of us as citizens. And the trend or the phenomenon of coalition government has made matters even worse. I think the case in point will be that Tshwane, where a budget was unable to be passed because of the coalition government. But I think what has been happening, and which is something that where I stay myself, is a situation whereby a provincial government will intervene through Section 139 in order to take over A or B, depending on what the intervention level is. But also, what we have realized as a city, that into obviously politics, but and there are a number of court cases which have been following Mapana local municipalities, one of them, and Lekwa local municipalities. That's where citizens took the municipality or the council to court for the court to make a decision. And at most times, the court will force the provincial government to intervene without the provincial government itself taking that decision. But what is more interesting, I think it was in February of this year, whereby a local municipality in the northwest, its obligation to give the local citizens or ratepayers services was given to a private citizens, whereby private citizens are running water and sewer, which is a new phenomenon. So what I'm trying to say in contributing to this issue is that citizens are not necessarily without any recourse. There is a trend or in our South African situation whereby they take the local municipality or the local government council to court, and courts have ruled for the favor of the citizens. And personally, I think that we do not need the provincial sphere of government, because I feel personally that it's a duplication of functions, and in fact, it hampers service delivery. That is the contribution I wanted to make, ma'am. Thank you.
Thank you so much for a detailed comment, and it was very enlightening. Then the last part where you indicate that you do not think the provincial governments are actually necessary. I could try to provide you with a brief historical background on what happened that South Africa ended up having provincial government. So during the negotiated settlement, there was a part where there was a need to deal with the composition and structure of government. Then the ANC was opposed to provinces, but the National Party, which was the ruling party by then, wanted to have provinces Why? Because they knew that their support was not dispersed across South Africa. So at least they could try to find one province or area which they could be concentrated, and in that form they could govern themselves. And there was a hope that they could win the Western Cape, so that the National Party or the Afrikaner, as it has been reported by some of the writers, could be concentrated in the Western Cape. Then the ANC wanted to have a unitary government where the absolute power will be the national government in order to ensure that they actually govern. And the concession at the end of the day was that there has to be 3 levels of government, including a province, then which will mirror a form of a federal government like you can see in the USA and Ethiopia. That's one of the factors that has led to South Africa adopting a quasi federal system where the constitution provides for all the 6 elements of a federation, but still we find that there is a stronger national government that resembles a unitary system at the end of the day. So that's why provinces were there. Then the question again was how to proceed with the new government. Then that's why the National Party ensured that at the end of the day, there is also a government of national unity, just to ensure that when the black ANC government comes into power, at least they could be able to have an influence on key decision making at national government. So some of the things that we are encountering now, and they do not just come overnight, but it was they are a mirror of what happened back then. So the negotiated settlement was not an easy thing to be achieved, but there was a lot of things that took place back then. So the National Party trying to protect the interest of whites who were leaving power, they could have their own provincial or regional space, to survive, and for the black majority who also wanted perhaps, to ensure that there is a huge transformation to the society as a whole. Thank you.
I see Tato's hand is up. Tato,
Hi. Am I audible?
you are, yes.
Oh, okay. Thanks. Thanks. I just wanted to ask. Um, as I was doing some work, assisting a law firm, I came across the concept of rationalizing the magisterial districts, the jurisdiction of magisterial districts, as well as the jurisdiction of high courts. And I just wanted to ask, is this something that's being done to keep in line with that principle of multi-level governance or not?
Uh, can I answer the question?
Yes, yes, please.
Oh, okay. So what you need to know is the creation of different spheres of government. It also meant that the different branches of government in the form of legislative, executive, and judicial bodies, they are also reflected at different spheres of government. So that's why you may find that there are also high courts that are mainly referred to as the uh, judicial provinces, and again municipalities, they also have got regional and district courts within them, just to ensure that the there is a decentralization of judicial authority within a municipality, to ensure that people still they have access to courts within the place that they reside within, or they do not find access to justice very difficult. So I could try to answer a question by looking at what is called judicial cooperation. So, where institutions and functionaries of the judicial authority meet the requirements of the Constitution is that judicial cooperation also requires that judges, judicial officers of different courts, they are able to coordinate their activities everywhere. So there is also an interjudicial dialogue where different judges, they share their own practices and are able to ensure that people on the ground, they've got access to such services. So usually in South Africa, such dialogues are not often held, but right now there is an emerging voice that such things need to be they need to be implemented. I guess I've been able to answer your question unless I've missed something there.
I think for the most part that's answered. And then the dialogues that are usually held, it's not something that ordinary members of the public can participate in.
In most cases, no, because mind you, judges, the process of appointment of judges and how they execute their duties, although the public could form part of the court proceedings, but they do not actually have the chance to voice their needs and interest with the judges, because obviously it's a different platform of the work of the judges or judicial officers altogether, as opposed to the elected public representatives in the form of local councillors, provincial legislative members, or I mean the provincial members of the executive, like the MEC and the yeah, see, and even the members of the national parliament who have got the constitutional obligation to engage with public representatives. For instance, with the national parliament, there is a requirement that parliamentarians execute their duties by going to parliament to represent the interest of the people, and again they go to communities and engage with them just to ensure that they listen to the people's needs on the ground and they represent them in parliament. And at local government, there are also ward committees, the imbizos that are being held to ensure that there is accountability and responsibility. But with the judges, it's a different story altogether. So the dialogue is mainly, I guess it's a discretion between the judicial officers themselves.
Was it the same also in apartheid times when the magistrates were, civil servants rather than members of the judiciary?
I could lie if I'm to answer that question, because honestly, I'm not sure of the context which took place during the apartheid era. But what I know for sure is that, like now, what is happening, judicial officers are there to apply and interpret the law according to the existing legal system. Or at least currently, with the new constitutional dispensation, South Africa now has got activist judges who ensure that they actually promote the best interest of the people at heart when they execute their duties. Then with the apartheid era system, obviously they were also there to ensure that the system, whether it's just or not, they apply and interpret the law as it is.
Okay. Okay, and then public policy. How is it only then from the case laws that they get a sense of what the public policy is, case law and statute? if there's no interaction at any of the levels with the members of the ordinary public, then how do you get a sense of what the public policy is?
The public policies are not the laws that are enacted by legislative bodies, but are policies that mainly emanates from the executive that is executing the laws, because it is the policy that gives a flesh to the law, and the policy formulation and making is I think it finds validity through public involvement. For instance, at the local level of government, there is a service delivery budget implementation plan, there is an integrated development plan, and several other developmental plans that require people to be involved in decision making. So such policies, I believe that they are able to reflect the needs, the aspirations, and the interest of the people if there is a public participation process. And obviously by law, there are mechanisms and structures that are there to ensure that people actually participate. Usually, if there is the municipality is preparing for an integrated development plan, which is the comprehensive development plan of a municipality, notices are being issued that people must come and participate on this day, in this venue, at this time. This is the agenda of the day, and people actually go and participate. But the only issue that I know that even if people do participate, but their voice do not actually are not their voices are not actually binding, is it relates to the consultations concerning the demarcation or dissolution and amalgamation of municipalities, like it has happened during the 2016 before the 2016 local government elections, where some of the communities like in Matatiele and Mirafong took the municipal demarcation board to court because such municipalities are being dissolved without the popular voice reflecting in the public participation process. So what I want to indicate is that a popular voice in a public meeting does not mean that that's the final decision that needs to be taken. Obviously, the decision makers have got their own rights, powers, and discretion to decide anyhow.
Okay. Okay. All right. Thanks so much.
Thank you.
Pilani, do you have another question? No.
Yes. My question concerns the spheres of government once again. We said that we have a quasi federal system, and we already know the reasons why we have that. And right now we are in a situation where we can see how it's not serving us, and how the bureaucracy sometimes it just does not do what it's meant to do, and actually just pass the bugs. Should we what the other system that is opposite to it, the unilateral one, should we have that system there? What would be the benefit right now of actually having a system that is not the quasi system that we have? Could we see better management of our finances? Could we see better service delivery? Because somebody else asked me that, what is the reason for having provinces, and that question was answered by that, but I could not actually answer it myself and say, because of like accountability when it comes to changing the constitution, that part I could actually see when you can't just have like just the 400 people in parliament just having to decide, okay, this is not just going to happen. Public consultation has to come down right down to everybody else for us to actually agree on it. And if it's something, and if it's a law that we do not want to actually pass, then we have a greater time to maneuver and try and engage people and maybe change mindsets and have more awareness of the consequences of such a law that might change the constitution drastically to a certain extent that in the future it actually causes more harm than good.
Okay. Thank you. And I think the utterances are more of a hybrid between comments and a question. And I think one of the important parts which you have raised is if whether we could alternatively use the unitary system. I can boldly state that I don't think the unitary system could work because the purpose for a multi-sphere of government or the purpose of sharing power with lower levels of government is to ensure that there is a dispersion of responsibilities to different corners of the country. That's why the constitution, it says that municipalities must be established in the whole territory of South Africa. This is to ensure that people are able to receive services in a more closer way. So if when you speak of a unitary system, you are talking about a system which has got the potential of absolute power that is vested mainly in one or single person or body at national level. And that's a recipe for disaster and dictatorship. So some of the reasons for decentralizing or sharing powers with provincial and local governments is to limit the centralization of power in the president or the presidency or the prime minister or the king, just to ensure that the system of checks and balances is not only vertical but is also horizontal. The lesser the powers the president has, the better for the society. So this is, sharing power with the provincial and local governments is to counter the abuse of centralized governments by limiting state power. This has to be done by dispersing powers across the different levels of government. In this regard, certain powers of the national government are often concentrated in this authoritarian president. You have seen perhaps in Zimbabwe, which is a typical example, especially during the era of President Mugabe. And this is still continues up until today, that the Constitution of Zimbabwe, in terms of section 264, it provides for a provincial government, and that provincial government needs to be led by a democratically elected metropolitan and provincial councils. Up until today, such councils have not been established, and the people who are leading provinces are called provincial governors that are unilaterally appointed by the president, who is obviously an authoritarian leader. So the only elected leaders, you may find that they are at national and local level. And some of the reasons, perhaps in Zimbabwe, that the provinces have not had elected leaders is because Zimbabwe has got a very strong unitary system. That's why even if they have different levels of government in a form of a tier that is hierarchical, provinces do not actually have real powers that are conferred on democratically elected people. Perhaps it's because in Zimbabwe, there are some provinces that are mainly comprised of people that belong to a certain ethnic group. In this regard, the Matabele's who are in Matabeleland North, Matabeleland South, and even in the province of Midland. So if you are to allow people of other provinces to elect their own leaders, you may find that they might perform more well as opposed to the other provinces. And mind you, if a province is doing well under a certain party that is not the same that is governing at national level, that in its own, it might influence how people can also vote during national elections, and that could tilt the balance of power. And the same has been experienced during the 2016 local government elections, where ANC lost control of Tshwane, Johannesburg, and the Nelson Mandela Metropolitan Municipality through coalitions. And it's because people got at least they learned, they became politically wise. They just observed that, okay, the ANC is fumbling, and with Jacob Zuma being in power, ANC being associated with corruption, at local level of government, people decided that let's give other people a chance. And if other parties are to govern well, meaning the national government can also have challenges in terms of gathering more support again into the national government. So you could see that having a quasi-federal system, at least it helps. We can have having a multi-level system of government. That is one of the key principles of South Africa's constitutional democracy. It is actually akin to the requirements of a multi-sphere of government as opposed to a unitary system. Thank you.
Thank you very much. You just confirmed my view that absolute power corrupts absolutely, and that it would be very dangerous for us to just say that we want a system right now that is that abolishes provinces and we just give power to just one central government. Yeah, and that is quite a dangerous route to even think about. And looking at the past 27 years, how we've actually got to where we are today. Yeah, no, thank you very much.
Thank you.
Okay, that seems to be bringing us to the end of the lecture. I'm not seeing any more questions. Thank you very much, Mr. Mudau, for the time you've taken. Yeah, almost 2 hours have passed. So shall we then leave it there and see each other again next week?
All right. Yeah. Thanks a lot, Prof. And I really appreciate the very challenging, interesting, exciting questions from.
I know. I know. That's the part that I find most exciting too with my lectures, is the interesting questions.
Yes.
No, thank you very much, students. We do appreciate your full participation. So thank you very much for joining us for this lecture. All right, thank you. Goodbye.
Bye-bye.
Thank you. Thanks.
Bye-bye.
Thank you. Bye.
Bye.
Thanks. Goodbye.
Bye.
Thank you. Bye.